So, good morning, everyone, and thank you for joining us for the latest of the Brodies Banking and Finance Academies. My name's Lindsay Lee. I'm a Senior Associate in the Brodies Banking and Finance team, and I'm joined by my colleagues Aileen McMillan and Craig Henry, who are really going to do most of the talking today. So today's session, we're looking at signing banking documents and getting that right so that completions can, as far as possible, run smoothly. And if we can get documents signed correctly first time, we can avoid the costs and delays of finding workarounds if that is possible, or of having to get documents re-signed. And the better that signatories understand what's required in terms of where and how to sign in banking transactions, the more efficient we can make sure that the signing mechanics are. So let's just look at what we're going to try and cover in today's session. So the first two bullet points, we're going to look at the wet ink or traditional signing and what's become increasingly common in the last couple of years, electronic signing. So we often act in transactions, whether those are national or international, where we have a mixture of English law governed and Scots law governed banking documents. And we're going to look at the similarities and differences of the signing requirements of those two types of documents, whether they're signed in wet ink or electronically. And as Ailey's going to explain, although there are similarities between the two, there's also some important differences which signatories north and south of the border really need to be alert to. Next, we'll look at witnessing requirements in England and Scotland, and we'll see how Scotland, currently at least, is more flexible than England around witnessing, particularly around remote signing, which we've seen a lot of in the last couple of years. And we'll also see in relation to electronic signing that electronic witnessing adds nothing to the execution of Scots law documents. Craig's also going to talk to us about mixed media signing. So that's where we have a mixture of wet ink and electronically signed documents, or where the document's being signed electronically, but on different platforms or by different electronic methods. And I think one thing that we'll take away from today's session is that not all electronic signatures are equal. Also going to look at counterparts execution, and we might have some folk here today who remember the olden days of Scots law when we didn't have the counterparts legislation. And in those days, we had everyone coming into one room to sign a document, or we had a round robin of sending the document around the houses. So now, thankfully, we can have signatories sign separate but identical copies of a contract and exchange them. And Craig's going to explain how we do that and how, although it is much simpler, it's really important to get it right. And then lastly, we're going to end on things that can go wrong and how we try to avoid or deal with them. And after that part of the talk, we'll then sort of launch into some Q&As on issues that arise from today's session. So if you have any questions, please do put them in the Q&A section, and we'll try to pick up as many of them as possible. If we don't have the chance to pick up your question today, if you could leave your name with your question, we will pick up with you directly afterwards. So without further ado, I will now hand over to Ailey to talk us through signing requirements in England and Scotland.
Thanks, Lindsay. So I'll be taking us through the next few slides, which will broadly cover signing deeds in England and signing in a self-proving manner in Scotland and the differences between the two. Signing in wet ink in Scotland, including the rationale and specific practicalities, as well as mercury rules which apply in England. And finally, electronic signing. So as a starting point, you might know that under Scots law and under English law, many contracts don't require to be signed in a specific way, or signed at all, in fact. But of course, in practice, we tend to follow formal signing requirements, and where necessary or appropriate, we would ensure that Scottish documents are signed in a probative manner and English documents are signed as deeds. So if we begin with signing in a probative manner under Scots law, i.e. a self-proving manner, this essentially means that a document has been signed in a way which would allow a court, if the point was under challenge, to assume that the document has been signed by the persons who have purported to sign that document without the need for evidence to be led on that point. So basically, the burden of proof would be on the party asserting that the document has not been validly signed. And this is why for documents such as security documents, many of which could be validly executed without being probative, we would still insist on probative signing. There are some documents which are under the relevant Scottish legislation, which is the Requirements of Writing Scotland Act 1995, required to be signed in this way. And these are things like Contracts are documents concerning rights over land, wills, and certain trust documents. So the position in England is different, but it's similar in that different formalities are to be followed depending on the circumstances. So under English law, there's a distinction between simple contracts and deeds. A simple contract is generally entered into by way of a straightforward signature. Again, there are certain English documents which are required to be executed in writing. So things like contracts for the sale of or conveyances of land, guarantees, and declarations over trust. So if we move on to deeds, signing as a deed in England is more in line with signing in a probative manner in Scotland. Certain documents require to be signed as a deed. So again, it's things like transfers of interest in land, mortgages, charges, and powers of attorney. And this comes with additional signing requirements. So the requirements would be that the document is in writing. It appears that the document is intended to take effect as a deed. It is validly executed and it has been delivered. And there are several options for signing. The most common we would see would be a company signing by two directors, or alternatively, a director in the presence of a witness. So if we go back to Scottish requirements, now that we've covered the requirement and rationale for probative signing, I thought it might be helpful to cover the practicalities of this form of signing. The rules are all contained in the 1995 Act, although it does take a bit of back and forth to the relevant sections to put together a cohesive guide. So I've popped up on the slide there an example of some standard signing instructions that we would issue. The instructions are quite specific, as you can see, and it can be quite easy to make mistakes, especially if a signatory is used to signing in other jurisdictions where they can simply print the execution page, sign, and scan it back. So before even looking at the instructions themselves, the document will have been set up in a way that the last clause of the document will appear on the same page of the first signing block. And this is called operative wording and is an important requirement. The instructions will then take the signatory through printing the full document as opposed to signing pages only. It will specify how many copies should be printed and then direct the signatory to the signing pages. And again, depending on the type of entity signing, there are a few different options here. So for example, a Scottish company can sign by two directors, a director and the secretary, or a director before a witness. And there's also an option for an authorised signatory to sign. So for example, where an individual has been appointed by a power of attorney, they could sign the document before a witness. For foreign entities, we would look to see an authorised signatory sign before a witness, and we would just ensure with the relevant local council that that would work from their perspective as well. The instructions then set out who should sign where, as well as the other information to be included in the signing block. So the date and place of signing is required to be included, and this is something that we do often see missed off, especially the date. And just to clarify, the date of signing isn't necessarily the date on which the document takes effect. It's simply a record of when and where the document was executed. If a witness is signing, they should also include an address, which can be a business address. And this is just for the purposes of identifying that person later if required. Under Scots law, a witness can be present via a video link, or the signatory can indicate to the witness after the fact that they have signed the document. But Craig will go into that in a little bit more detail shortly. And you will see there at the end of the instructions that all signatures should represent either the full name or first initial and surname of that signatory. And this is another important requirement from the legislation. And there have been instances of documents being rejected at the land register because this hasn't been followed. Signed documents should then be scanned back in full and sent to the relevant council for checking. Under English law, Mercury rules apply, where documents can be returned by sending the execution version of the document with the signature page only and confirming that the signed page relates to that execution version. Mercury rules don't actually apply in Scotland, and this has been quite tricky with various lockdown restrictions over the past couple of years. So it is quite important to know in advance who your signatory will be and whether that signatory has printing and scanning facilities. And there are a few workarounds that can come up if that's not the case. So just touching on workarounds there has been a significant shift in the market towards electronic signing of documents. Electronic signatures are generally valid, though there are difficulties with documents which must be or should be signed in a probative manner. There are different levels of e-signature in terms of the security provided, and you can see the three of them up there on the slide. So we've got a simple electronic signature, an advanced electronic signature, and then the highest level in terms of security would be a qualified electronic signature. A simple electronic signature, that would be the most basic type, and that includes, everything from ticking a box on a website to agree to terms and conditions and uploading a photograph of a signature. An advanced electronic signature provides a higher level of evidence than simple signatures, but additional criteria needs to be met. So the signature must be uniquely linked to that signatory. The signature must be capable of identifying the signatory. It must be created using data that the signatory can, with a high level of confidence, use under their sole control. And it must be linked to signed data in such a way that any subsequent change to the data is detectable. So it is quite a high standard, even for that level of advanced electronic signature. The qualified electronic signature is a further step up, and that's effectively an advanced electronic signature that is A, created by a specific QES device, and B, is based on a qualified certificate for electronic signatures, so effectively supporting data that verifies the signature is valid and links it to the named signatory. In the context of Scottish documents, an AES would be sufficient to provide formal validity for the purposes of the 1995 Act for most types of documents. However, a QES is required in order for a Scottish document to be probative. Only certain e-signing platforms are able to provide the optionality for QES. So in practice, where a document is to be signed in a probative manner, such as security documents, as I mentioned before, it would still have to be executed in wet ink. And one point to note as well is that the Land Register doesn't currently accept electronically signed documents. So in those instances, the documents would need to be signed in wet ink in any event. English law takes a more relaxed approach to electronic signing, where no particular form of signature is prescribed under common law. So unless it would be provided in legislation, contractual arrangements, or case law, common law would apply. And the key question regarding electronic signing under English law is whether the method of signature adopted demonstrates an authenticating intention. So in terms of deeds, the general position tends to be that an electronic signature may be used to execute a deed, provided that the deed is in writing, the signature is inserted in the deed in order to authenticate it, and the signature is witnessed as required. But again, it should be noted that just like in Scotland, there are some registers which require wet ink signatures for registration purposes. So I'll now pass over to Craig to go through witnessing, mixed media signing, and counterparts execution.
Great, thanks very much, Ellie. So in the context of coordinating signings and completions over the course of the pandemic, we've received lots of queries around witnessing, and particularly in periods where more restrictive isolation and social distancing measures have been in place. Moreover, and as electronic signing has emerged as a more widely used method of signing in recent years, as Ailey mentioned, and most notably over the course of the pandemic in the last few years, a wider consideration of practicalities surrounding witnessing of signatures has been required both in the Scottish context as well as in England and Wales. So in this regard, we're now going to consider the possibilities of, firstly, remote witnessing, and then secondly, witnessing an electronic signature as a matter of Scots law and English law, respectively. So firstly, to consider the position as regards remote witnessing of wet ink signatures in Scotland, it would appear that remote witnessing is possible as a matter of Scots law. For example, this would include witnessing by video link. So this is by virtue of section 37A of the 1995 Act, which states that a person witnesses a grantor's subscription of a document if he sees the grantor subscribe it. There's not a requirement for the witness to be physically present in the legislation. So in support of this, the Law Society of Scotland has issued guidance on witnessing wills that states that video link witnessing is permissible. And we would consider that this guidance can be applied equally to other documents as well. In terms of process, and as set out in the Law Society, by the Law Society in its wills guidance, as long as a witness has seen the individual actually sign by video link, the witness can then, on receipt of the original signed document, legitimately sign and complete the witness block without further reference to the grantor. So the Law Society anticipates that this would be deemed to form one continuous process, as is required by the 1995 Act. It should be noted that it's generally permissible for a family member or other members of the same household to act as a witness. And in my own personal experience throughout the pandemic, family member witnesses were more commonly relied upon instead of remote witnesses. However, it's still helpful to be reminded that remote witnessing is possible for wet ink signatures in Scotland. Similarly, and as touched on by Ailey earlier, pursuant to section 37B of the 1995 Act, it's also possible for a signatory to acknowledge their signature to a witness at a point after their signing of a document. So this can be used where a witness hasn't actually seen the grantor sign the applicable document. And now to move on to electronic signatures, and by contrast, it's not possible as a matter of Scots law for an electronically signed document to be witnessed, or at least for any legal benefit to be obtained by such witnessing. So just to take a step back, witnessing is generally used in Scottish documents in order for a signature to obtain probative status under the 1995 Act, i.e. such a document will be presumed to have been validly executed by the relevant party. Now, as Ailey covered earlier, there are three separate types of electronic signature that are recognised in Scotland. There's simple electronic signature, advanced electronic signature, and qualified electronic signature. Only a qualified electronic signature, a QES, provides the benefit of the presumption of a valid signature as a matter of Scots law. And it's not possible for either a simple or advanced electronic signature to benefit from that presumption, even if such a signature is witnessed and the witness then signs the document. And so these areas are areas in which Scots law actually diverges with the position in England and Wales. So firstly, to look at the legislative context of witnessing in England, the Law of Property, Miscellaneous Provisions Act 1989 in respect of deed signing by an individual, and the Companies Act 2006 in respect of deed signing by a corporate entity require that the relevant deed is signed in the presence of a witness. So contemplating remote signing here, it's not clear from the legislative context whether this requires for a witness to be physically present, or whether remote witnessing by video link would be sufficient. So given the lack of certainty here, and to ensure that a deed has been validly executed, the Law Society in England has stated that any witness to a signature, whether that's a wet ink or an electronic signature, should be physically present to witness the act of signing. And by way of clarification, and given the context of national lockdowns have often required physical distancing measures, the Law Society have confirmed that witnessing through a window, whether that's open or closed, or at a distance or in an outside public place, are all also sufficient to meet this standard. In this context, it's also important to note that there have been some limited exceptions in which remote witnessing by video link has been permitted over the course of the pandemic. For example, the Wills Act 1837 permitted witnessing by means of video link between 31st January 2020 and 31st January 2022. However, the general rule remains that a witness requires to be physically present as regards English law documents, and so it generally isn't possible for remote witnessing to be used in England and Wales. So while the physical presence of a witness is required for the purposes of valid witnessing in England as opposed to Scotland, which allows remote witnessing, it is possible as a matter of English law for a person to act as a witness in respect of an electronic signature. So just again, to consider the context in England, the concept of a self-proving signature isn't relevant south of the border. However, certain documents may require a witness to sign, in particular in the context of signing of deeds. So in contrast to the position in Scotland, this means that where a signatory has applied their electronic signature to a document, a person who has been physically present and observed the application of that signature can thereafter sign that document as a witness. So as regards requirements, the e-signature can be in any form, subject to any statutory or contractual requirements relating to execution, which should always be checked in advance. But what matters, as Ailey said earlier, is the authenticating intention of the person who is signing the document as a witness. So now, having considered the position in relation to remote witnessing and electronic witnessing in Scotland and England, we'll now move on to consider mixed media signing. As Lindsay mentioned earlier, and I hope you'll all be pleased to hear, we're not about to take a wild tangent to consider whether you can sign something validly by applying papier-mâché or Play-Doh or anything of the like. Rather, what we mean by mixed media is whether it's valid for different parties to a document to sign by different methods, i.e. some signing by wet ink and others signing electronically. So given the range of e-signing platforms available, it's also helpful to consider the position and feasibility for different parties to sign using different methods in terms of platforms. So one party might sign using DocuSign and another signing using Adobe Sign. And I'm not getting paid for any advertising, just to note. Firstly, and to consider the Scottish context, it is possible as a matter of Scots law for parties to sign by different methods, i.e. a mixture of wet ink and electronic signing. So this has been confirmed by the Law Society of Scotland's Guide to Electronic Signatures. Similarly, the Law Society of Scotland has also confirmed that it's acceptable for parties to sign using separate e-signing platforms as a matter of Scots law. However, the question then arises, what constitutes, or how do you constitute the single document, given that counterparts will be held in different environments? So a wet ink counterpart and an electronic counterpart that can't be merged, or otherwise it might be two separate electronic files, which oftentimes can't be merged without losing the e-signing metadata, which is important for security purposes. So the Law Society has confirmed that the single document in such circumstances, whether in the context of mixed media signing or where separate e-signing platforms have been used, will comprise all of the counterparts in their entirety, notwithstanding that they can't be physically or digitally merged in each case. In England, the position is similar. So the Law Society Company Law Committee and the City of London Law Society Company Law and Financial Law Committees have published a note providing guidance on this topic. So if one or some parties to a document, including any witnesses, wish to sign using an electronic signature, while others would prefer to use another acceptable method, such as wet ink signing, and there's no reason why the document can't be signed using a combination of different methods, so long as each party uses a valid signing method. In terms of collating, where a document's been executed using a combination of electronic and wet ink signatures, the parties or their legal advisors might want to create a composite document. So this would be done either by using a hard copy printout of the electronically signed document and collating this with the wet ink signed pages, or otherwise scanning the wet ink signed pages and creating a composite electronic document. To the extent that the document is required to be produced in evidence, and the committees in their note stated an English court would accept this composite document. Equally and similarly to the position in Scotland, it is also possible for separate parties to a document to sign using separate e-signing platforms in England. Helpfully, the Land Registry in England has also confirmed that this is acceptable, though as Ailey noted earlier, certain documents do still need to be submitted to them in wet ink form. So as regards mixed media signing and the use of different e-signing platforms, it's really helpful that both Scots law and English law are flexible in respect of these areas. However, it does generally make practical sense for parties to use the same methods or platforms for signing. So this assists in creating an easier to follow audit trail and also allows signed counterparts to be stored in the same manner. And so we'd recommend the parties sign using the same method wherever that's possible. Equally, in terms of e-signing, it's also generally easier for one of the parties or their advisors to coordinate the signing by all applicable parties to a document through an individual signing platform, rather than coordinating different parties signing by separate programs. Finally, and just before I pass back to Lindsay, we're going to move on to briefly consider signing in counterparts in both Scotland and England. So by way of summary of the Scottish and English contexts, as a matter of Scots law, it was historically not possible for documents to be signed in counterpart. So documents, they used to have to be signed on the same copy by all parties. And so Scottish documents had to be passed around the houses, so to speak, or otherwise all the parties had to coordinate to meet in a single place, for example, a signing or completion meeting to arrange for signing of the Scots law governed documents. Thankfully, this all changed with the introduction of the Legal Writings, Counterparts and Delivery Scotland Act 2015, which permits parties to sign separate, identical counterparts of a document. As I'm sure you're all aware, this has greatly simplified the logistics around signing of Scots law governed documents. By contrast, counterpart signing in England doesn't have a legislative basis. Rather, counterpart signing evolved through custom and practice as an acceptable means of signing down south. So while both jurisdictions permit counterpart signing, it is important to note there are differences as regards practice and requirements in both contexts. Just to highlight a couple of these, firstly, in Scotland, a document will not be validly signed if only a signing page is printed, executed, and returned. So Scots law requires that the full counterpart of the final execution form document is printed and then signed. This is in contrast to the position in England, which permits for single signing pages to be printed, signed, and returned. Moreover, while English law governed deeds and real estate contracts must be in final agreed form before they're signed by parties, where a document isn't a deed and it isn't a real estate contract, it is possible, as a matter of English law, for signing pages to be signed in advance before the document itself is finalised, which is something that rings very strangely in a Scots lawyer's ears. Secondly, and just as another important point to note, in Scotland, there's not a requirement for a counterparts clause to be included in a document. The one is often included in practice to set out the basis of execution and delivery. And meanwhile, in England, it is common practice for a counterparts clause to be included in any document which is being executed in counterpart. So I hope that's been a helpful run through of witnessing, mixed media and counterpart signing in Scotland and England. Lindsay's now going to lead us through what for me is the most anxiety-inducing part of today's seminar. It's the potential pitfalls of completions and signings, but thankfully also tips on how to avoid these.
Thanks, Craig. Yeah, we thought that we would use this part of the talk to look at the sorts of signing issues that we see crop up in Scots law documents and how we deal with them. There's been a few hints and clues in what Ailey and Craig have been saying as to what these issues might be. And I think probably the best advice we can give to avoid any signing hiccups is to really pay close and detailed attention to the signing instructions. As Ailey's shown, these really do walk you through step by step the whole signing process. And I think if you do that, you really reduce your risk of or increase your risk of getting your signing right. And as a belt and braces approach, what we do is we ask signatories to scan back what they've signed to us, just so we can have a quick check of it before they then send back the originals. And that gives us time to fix any sort of signing mistakes there and then, and avoid any potential headaches later on. So other things that we see cropping up with Scots law documents is in relation to the signing blocks. So this can happen because of how a document's printed off, or because if there's last minute changes are made, particularly maybe by someone who isn't aware that there are differences between Scots law and English law signing blocks. These differ in content and where they appear in the agreement, and there's also differences as to how they should be signed. So Scots law signature blocks start on the last page of the contract, excluding a schedule. So if you've got a schedule, your signature blocks would appear before that, and the first signatory has to sign on the last page, and the last page has to contain some operative wording from the agreement. So that's normally all or part of your last clause of the contract. So page breaks can be quite important. English signing blocks, on the other hand, appear at the end of the contracts. If you've got schedules or appendices, you will get your signing page right at the very end after those. As Ailey's mentioned, Scottish signing blocks usually include the date and place of signatures, and these need to be inserted by the signing parties. The date of signature, again, which Ailey highlighted, is added in the signing block. It's not inserted in the date of the agreement at the top of the first page. And the place should also be your geographical location. So it's your city, town, village. And also importantly, signatories should complete their full names and witnesses should complete their full names and print those out on the signing block. Also, if it's a company signing and you have maybe options under the signing line for director, secretary, or authorized signatory, it's important for the signatory to score out those which do not apply to them. So if it's a director, they can delete out secretary or authorized signatory. English signing blocks don't usually include the date and place of signing, and instead the date of agreement is normally put on the top of the first page of the contract or the agreement. Another area where we see signing issues coming up are in relation to schedules to Scots law documents. So if we've got a schedule that consists of a plan or a property plan or a drawing or a photograph of property, or it contains a written property description, there are additional signing requirements which signatories just need to be aware of. If you've got a plan or a drawing or a photograph, the schedule has to be executed on each page. And if you have a written property description, for example, a title number, and that's in the schedule, the schedule itself has to be executed on the last page. It's important to get those things right. I think Ailey flagged this because if the document's got to be registered with the land registered, because they could get bounced if they're not properly signed. Worth also noting that your schedules or annexations or plans don't have to be witnessed. So not signing a schedule, as I've said, is something that we see is quite an easy signing issue to be overlooked. And what we try to do if we're dealing with maybe a single or a couple of properties in a banking document, we try and include the property description in the body of the agreement itself and not put it in a schedule, so that then we don't trigger the requirement for the extra signatures. So that works well if you, as say, you've got one or two properties. It obviously doesn't get us where we need to be if we've got lots of properties involved in our banking transaction. Another issue we see happening is where the delivery date is inserted prematurely, and I think our advice would be just leave that for the lawyers to complete. Another issue is also not keeping or discarding originals. If we, for example, have to file charges at Companies House, we need to be able to file a certified true copy, and in order to certify a copy as a true copy, we need to see the original. But even for documents that don't need to be filed in a register, if ever you have to found on those or lead those documents in a court process, the best evidence that you will have are the actual originals themselves. So it's really important that they're kept in a safe place. And then finally, the last one I was going to pick out is only printing off the signature page for signing. As Ailey's and Craig both mentioned, Scots law requires the whole document to be printed off for signing. If you're signing in counterparts after you've printed off the whole document and signed it, you can scan back just the signature page and send back the whole, the original, by post or courier. But it's really important requirement of Scots law that you print off the whole document before signing the last page. So that really covers some of the common pitfalls that we come across. And as I say, I think our best advice is to just, as far as possible, follow the signing instructions and just work methodically through those. So that ends the kind of formal part of today's session. Moving now on to questions. Just to start things off, I've talked, and I know Ailey also have, we talked about printing and scanning documents, but not everyone has a printer or a scanner, and I include myself in that. You mentioned workarounds earlier, Ailey. What sort of things have we been doing to help people out in these situations?
Yeah, that's right. And I think especially, as you see, over the past couple of years, more and more people are working from home and don't necessarily have easy access to printing and scanning facilities. So I would say best course of action is to try and bottom out as early as you can in a transaction who your signatory is, where they are, and what the situation is with facilities. What we've been able to do before is have bundles of documents couriered to a signatory. And they've been able to sign as normal and then send back by taking photographs on their phone. So yeah, that's kind of covered that off. But as I say, the earlier that you're able to work out who's signing what and where they are, the better.
Yeah. And I mentioned registering documents to the land register and the importance of signing schedules correctly. What, just staying with you again, Ailey, what sorts of other signing issues do we come across where in banking transactions where our documents have to be filed in the land register?
Yeah, so I did mention there's quite a specific rule that's contained in the 1995 Act where the form of signature should be the person's full name or their first initial and surname, so Ailey McMillan or E. McMillan. And when the land register, when it doesn't appear that that's the case, the documents can be bounced. What the land register do seem to find acceptable though is if they're unsure whether or not a signatory meets that requirement, they'll ask the question, and if the signatory is able to confirm just by a simple email that that signature does indeed cover their first initial and surname or full name, the land register seems happy to proceed on that basis.
Great, thanks, Ailey. Craig, one for you. We've talked a lot about the legal requirements for, say, a company signing, but often banks and other lenders, for example, will have their own internal signing protocols. And if we're dealing with non-UK entities, they will have their own internal signing requirements, but also their jurisdictional legal requirements too. What happens where the legal requirements and the internal signing protocols don't quite marry up?
Yeah, it's a really good question, and again, it's something that we come into contact with quite frequently on transactions. As an initial kind of point, and as we've mentioned quite a few times over the course of today's webinar, is to check in advance what's required. So flagging far in advance of completion as you can, whether any institutions or any parties you're working with do have internal requirements. So where those requirements don't quite match up with Scots also kind of by way of a tangible example would often be where it's a non-UK entity that is signing a document under Scots law that would require both the signature of a kind of director or authorised signatory, but signing in the presence of a witness. But sometimes these institutions would often have an internal requirement to sign by 2 authorised signatories or 2 directors or the like. So in those circumstances, it's important that both the internal kind of institution requirements are met, but also the legislative requirements are needed as a matter of Scots law. So in those circumstances, we look to set up the document in advance to make sure it's able to be compliant with both sets of requirements. So just in that example, setting up for signing by 2 directors together in the presence of a witness. There have been instances where it has been flagged to us late in the day. Another way you can get comfortable with that situation is a matter of Scots laws where, say there's 2 directors who've signed, confirming that one of those directors, if they have signed in the presence of the other, that in that circumstance, the second director can act as a witness then of that first director. And so you would have both the internal requirement met of 2 directors, but also the director signing in the presence of a witness for Scots law purposes.
Great, thanks, Craig. I'm just keeping a keen eye on the clock at the moment. We're just out of time, so I'll need to draw things to a close. But I think if we're looking for 2 key takeaways amongst many others from today, it's probably to have a clear line of sight early on in our banking transaction as to who's going to be signing the documents, and again, to pay close attention to the signing instructions for the documents that you are actually signing. We are out of time. thank you very much for joining us today. We hope you found the discussion helpful and that you're able to join us for future Academy sessions. As we close down the webinar, if you could please help us by taking your time to complete the short 1-minute survey at the end, that would be really helpful for us in moulding future webinars. But with that, all that remains is for me to say thank you very much for joining us, and goodbye.